little good consensual work is being done. You don't want it to be lost by the glare of cameras. So a lot of work outside of parliamentary session is also lost to parliament. That's one loss. Second loss is to the people of his constituency. They have an elected representative, Mr. X. He may be good, bad, or indifferent. He's their choice. It's not my choice. It's their choice. Their choice loses its voice. Their choice loses their voice. These are not mere empty rhetoric. These are practical. In a democracy, the Lordship knows we live by fictions. When a decision is taken by 700, 800 people in parliament, it need not be that everybody who is elected them agrees with it. But the fiction is that you are elected and therefore you have the right to enact a law which is deemed to be their will. They are the electorate. So in the same way, on that fiction, that entire right of that collectivity known as we the people is lost. The third loss is to the nation, because ultimately what is the collectivity across? So one is personal, one is constituency, the third is to the entire collectivity of parliamentary democracy, because parliamentary democracy is made of a collection of those constituencies. Therefore, your lordship would have to consider, can any of these be reversed? We are on reversibility, balance of convenience. I gave lordship two simple examples. Assume, now example number one is that what is already lost, we are now arguing on 2nd or something of May. So what is lost from the date till now is lost. It is that I can't think of any way in which your lordship can restore it. I mean, a court is only human. A court is not supernatural that can restore. How can a lordship restore it? Nobody can restore it. There's another thing. Suppose this lingers on even for a day. I mean, a day means any small length of time. The election commission is absolutely under no obligation that Mr. Singhvi is arguing here and Mr. Nanavati is arguing there, and there is something going on there. They say that this constituency will not go unrepresented. As I told you last time, that limit of time can be as little as 3 months. It can extend sometimes to 5-6 months. Well, if the election is declared, and after that, there's another thing which happens. Once an election is declared, the normal window is about 6 weeks. The moment that notification declaring a by-election, not even election, a by-election comes, the lordship knows everything stops. Your lordship doesn't interfere on that old fiction that now you challenge after the election. So the entirety of that thing can't be stopped. Thereafter, Mr. Rahul is elected. Can I come and say, please unseat Rahul because your lordship was hearing my matter? Can anybody say that? Or your lordship says, now there's a third example. I've given third example. Your lordships in the course of either before Mr. Rahul is elected or 3 months after he is elected, the primary sessions court acquits me. It's very easy. Tough luck, Mr. Singhvi, go and fight an election again.
Yes.
To make that balance, your lordship has a provision for stay of conviction. It is for that reason alone. Then there is a outer fourth facet, the cost on the exchequer of the election. Look at the concentric circles your lordship has: personal core, collectivity, constituency, larger collectivities of parliamentary democracy, and then the cost to the exchequer of having an election actually with a man already elected who has not completed his tenure but who is subject to litigation, where he is arguing 389. This is a classic case. That is the real test. All this thing my learned friends are telling a lordship about how serious it is, or the evidence is only to satisfy lordship's conscience. Ultimately, the lordship test is only this. Now, in that light, just see two paras of a judgment called State of Rajasthan versus Salman Salim Khan, 2015. Just para 21 and 22. 2015, volume 15 SCC, 666.
Which para you are?
Para 21 and 22. No, for the court. May I read 21?
Yes.
Page 7.
if some foreign country is not granting permission to visit the country on the ground that the respondent has been convicted of an offense and has been sentenced for 5 years of imprisonment under the Indian law, the said order cannot be a ground to stay the order of conviction. If an order of conviction in any manner is causing irreversible consequence of injustice to the respondent, it was open to the court to consider the same. Mark this line. Irreversibility will vary. Your lordship is the judge of irreversibility. If the court comes to a definite conclusion that irreversible consequences and injustice would be caused to the accused, which could not be restored, it was well within the domain of the court to stay the conviction. No such ground has been shown by the High Court while passing the impugned order. Further, we find that now more than 1 year has passed and there is nothing to record that the respondent has to visit the UK again. That's for shooting of a film. That's the facts of that case. For the reasons aforesaid, we set aside the impugned judgment passed by the High Court of Rajasthan and Jodhpur, Salman Khan, etc. Remit the case to the High Court to decide the matter afresh. We open to the respondent to show that if the order of conviction is not stayed, it will cause irreversible consequence injustice to him, which cannot be undone if he ultimately succeeds. We open to the state to oppose each prayer. Well, I am saying these are actually much weaker cases compared to mine. Ex hypothesi, the nature of the post I hold is such that the consequence is completely irreversible. Ex hypothesi. It is something which doesn't need to be stated. It cannot possibly be restored. Now let us kindly see Navjot Singh Sidhu, para 20 to 23. Now remember, Malas, this was a murder charge.
Last order of Supreme Court under which he has to undergo conviction and he has to remain in jail.
Now I had the privilege of arguing that for him, that 1 year thing. But when the matter started,
yes,
this was a case of my learned friend was there also.
Was by case note when he was acquitted. Review Mr. Singhvi.
It started with what is the 302 charge. The charge basically, let's forget what is 302, 304. I'm asking myself, am I anywhere near 302, 304, and 30? Am I anywhere near that? I'm in a different world
And
as far as those sections are concerned.
subsection 4 was live when Navjot Singh Sidhu died, which was subsequently declared otherwise.
Yes, yes.
So that-
No,
but Then he
no.
offered to resign. That's all that happened.
Kindly see what is para 20 onwards. I am now not on that. The law is now very clear in 83 and 389. Now we are on what is the point that it is wrong to think that the moment you are convicted, Parliament becomes a barred area for you. That's not the approach. Under controlled conditions, you are still entitled to be in Parliament. That controlled condition now is suspension. It was suspension then also, but there was an automatic continuance given, which law was changed. It is not that your lordships has well as a completely barring effect. That's what I'm reading. Mr. Dwivedi, for the complainant, I'm reading para 20 verse,
yes,
has submitted that in order to maintain purity and probity in public, this was the argument which was rejected. Probity in public bodies, criminalization of politics has to be stopped, and persons who have been convicted of any offense should not be allowed to enter Parliament. Now, this is actually the approach which has to be seen. He has elaborated his argument by submitting that irrespective of quantum of sentence, if a person is convicted for an offense referred to in 8.1, where the punishment imposed may be only a fine. That's exactly the point I'm arguing. A simple imprisonment, small punishment. Even then, Mr. Dwivedi says, no, doesn't matter. Out, you're out. A person will incur the disqualification from the date of conviction, which will remain for a period of 6 years. And this evinces the intention of the legislature that convicts should not enter the precincts of Parliament or legislature. I'm on this narrow issue. I'm not arguing the current issue. I am saying the precise argument was raised twofold. One, please don't look at moral turpitude and seriousness. Any offense and zero tolerance, you can't enter Parliament till you get an acquittal or you're out completely. That was the argument. In our opinion, the contention raised cannot be accepted. The preamble to the Representation of People's Act of 1951 is quoted, and just see that, Willis. An act to provide for the conduct of elections to the Houses of Parliament, to the Houses of Legislature, qualification and disqualification of membership, corrupt practices, other offences, etc. The Act provides not only the eligibility and qualification for membership of the House of People and Legislative Assembly, but also for disqualification on conviction and other matters. Parliament, in its wisdom, having made a specific provision for disqualification on conviction by enacting 8, it is not for the court to abridge or expand the same. The decisions of this court rendered in Ramanarang and Ravikant Patil. Now, my lordship, remember when I opened it, I gave a lordship these
Yes.
judgments, and I gave the pages in the test also. Having recognized the power possessed by the Court of Appeal to suspend or stay an order of the conviction, and having also laid down the parameters for exercise of such power, not possible to hold as a matter of rule or to lay down, not possible to hold as a matter of rule or to lay down, that in order to prevent any person who has committed an offence from entering Parliament or the Assembly, the order of conviction should not be suspended. The courts have to interpret the law as it stands and not on considerations. Your lordship is really being argued today by the other side as if well, this is some kind of a heinous situation where the moment I'm convicted, you can't touch it, he can't enter Parliament. The whole law of suspension is made only so he can enter Parliament. So that all these 4 tests of personal laws, constituency laws, parliamentary democracy, and cost to exchequer are balanced depending on the context of a case. Shri Dwivedi has also submitted that once an accused has been convicted, it is only the execution of the sentence which can be suspended, and the order of conviction cannot be suspended or stayed. This is one again. Now your lordship is hearing conviction stay because it's been settled by the Supreme. Otherwise, the argument was you can't stay conviction. You can stay a sentence, so what? Now see how it's answered. Go down 5 lines in para 22. The contention is that the appellant would not be absolved of the disqualification even if an order of suspension or stay of the conviction is passed by this court. We are dealing here with the limited question, the prayer made by the appellant for suspending or staying the order of conviction. We are not required to adjudicate upon the question as to what will be the effect of the order, and further whether he will continue to be disqualified for the purpose of contesting the election, even if the prayer made by the appellant is granted, as such an issue is wholly alien to the present controversy, which can arise only in an election petition where the validity of the election may be called in question. Now, whether he can fight an election in a particular election petition, what ground somebody will take, I don't understand why anybody should agonize on that. Then, the very last part of para 23, because Mr. Dwivedi made a 3rd submission. Just see the last 5 lines of para 23. It would be a sublime public policy that the convicted person is kept under disability of conviction instead of keeping the sentence of imprisonment in abeyance till disposal of the appeal. In such cases, it is obvious to be highly improper to suspend the order of conviction of public servant, which would enable him to occupy the same office which he has misused. This is another point, Wallace. Suppose, Wallace, I am convicted of an offense which involves the very chair which will be activated if your lordship stays. I can't think of it. Suppose, Wallace, I mean, the offense involves, Wallace, something very unruly or slapping up servant while I'm sitting inside Parliament on a particular chair. Your lordship may have a consideration that reinstating me in Parliament will, Wallace, activate that very offense again. That is not the case here, is what the court is saying. Certainly, it is not the case in my case at all, Wallace. Cannot be the case. Namely, your lordship's stay of conviction enables me or puts me in a position potentially to repeat the offense. Now, Wallace, kindly just look at a few other things. There is no, Wallace, prima facie finding of relevance. I will call it as relevant prima facie. There are findings. Relevant prima facie finding, which will disentitle me to stay of conviction as far as the Sessions Court is concerned, and hardly any in the trial court. I'll give your lordship an example straight away. What appears to have weighed in writing in the Sessions Court, and your lordship saw it with me last time, your lordship knows the papers, is A, that the derogatory remarks are made against a personage as high as the Honorable Prime Minister. I entirely agree. that would be a relevant consideration provided any of the persons named had been a complainant. Nobody is denying that the position is very high and sovereign, but we are not concerned with that complaint. So that consideration, how is it found place in the Sessions Court? I don't know. It appears that it's been colored by that. And that is an irrelevant consideration. With the greatest respect, that's an irrelevant consideration. Yes. Since there is a direct bar, I cannot proxy prosecute. There is no proxy prosecutor, I prosecute for him. The whole reason of this 13 crore business, I argued at great length last time, I don't want to repeat it, is because he is not prosecuting, the complainant is not the person named in that statement. That's why this 13 crore business, one person in the class has been brought in. That's consideration number one in the Sessions Court. Second consideration is that because the accused, me, is a public servant, I need to be dealt with more sternly. This is found in both the courts. With great respect, that is very unfair. I gave a simple example. Forget this case again. Take a case where Mr. Rahul commits an offense and Mr. Singhvi commits an offense. If you're identical, you're not supposed to assume it is identical. But if Mr. Rahul's act, not offense, Mr. Rahul's act is not an offense, then Mr. Singhvi's act cannot be an offense, merely because Mr. Singhvi is a public servant. I hope I'm clear. It is the act which has to be an offense, not because Mr. Singhvi is occupied. I understand, if your lordship finds Mr. Singhvi guilty, then your lordship may give us a little more punishment because he is holding some position as a public servant. But that can't be the test, liable to be dealt with more sternly. There is no question, that if it is, you have to see individually whether a statement where no named person is a complainant is liable to criminal defamation because you are one amongst a class of 13 crores. That's a legal issue. It doesn't matter how high the person is, and it doesn't matter whether the accused happens to be a public servant or not. The third is that a speech given during a campaign stands on a different footing. Look at the errors. It's writ large, the error. As a matter of fact, your lordship gives a little more license. The lordship sees the kind of things being said. I don't support most of them this way or that way. But in the heat of the moment in a campaign, 19(1)A acquires a fuller bloom, not a lesser bloom. It's not a wilting flower. It's, if at all, a more blooming flower. Well, the impugned order seems to think that people will be more subdued during the course of an election campaign. It's just the opposite is true, If there is a free speech right, nobody is saying that because I'm giving election speech, I can violate defamation law. That's not the point. I'm giving the one by one reasons given by the learned judge. Reason number one is wrong. Reason number two, I'm now on reason number three. Reason number three is there a speech given during the course of election campaign on a different footing. No. You have to individually judge, as I said, same test, whether his statement is defamation. If it is, then whether it is given in a speech or not, it's equally culpable. But if it is not, the fact that Rahul said it in a speech will not make it more culpable. Then, the fourth reason is related. The complainant, being an ex-minister involved in public life, certainly suffered harm in his reputation. That's the fourth reason given at page 69. You lordship have seen these reasons. Yes. Huh? Now, actually, again, the opposite is true. Of course, apart from the thing which your lordship has said repeatedly, one of the greatest qualities when you're in public life is to be thick-skinned, not thin-skinned. Thick skin is a great attribute and a great virtue in public life. Nobody has the business of being oversensitive and say that I have been in public life, I'm an ex-minister, but I'm so sensitive that the moment somebody sneezes, I feel. Here, this person is aggrieved and hurt because he's 1 out of 13 crore people, is what he says. But that apart, yes. Yes. And therefore, this whole approach that he, being an ex-minister involved in public life, should be in that sense slightly more protected. Just the opposite is true. As they say, if you go into public life, you are submitting yourself as they say, to the brickbats of public life, and you must have a little more thick skin. The fifth error in the same page, same sentence, 69, same page, is Balas speculation, pure speculative findings, pure hypothetical findings. And one sentence makes it clear, Balas. Such defamatory remarks, he's talking about the complainant, Balas, the ex-minister. Such defamatory remarks, I'm reading word to word, would have certainly harmed his reputation and caused him pain and agony in society. That's not the test at all. The test is not to find that man who's the weakest link in the chain, who's hypersensitive, and say, look, all these people here would not be harmed. But that one man at the end of the room is so hypersensitive, he might have been, he would have been. And therefore, I will apply the law of defamation, his test. Because would have been harmed means, what is he harmed? What has he shown? He's only got one sentence case. My name is so-and-so, I'm a class of 13 crore, I am also defamed. At the end of the day, that's the whole case. That, Balas, is a purely speculative, hypothetical, incomplete kind of an allegation. Forget the proof. Then I made my point about identifiable class. I'm not going to repeat that because I've given out the case law. That is the single most jurisdictional important point in this case. Jurisdictionally, Balas, the whole law of defamation was never intended. I made it in great detail last time. I'm in the jointed. I'm not repeating. Your lordship is being asked to do violence to the concept of an identity. How can a class of 13 crores be an identifiable class? By very definition. We've argued all the names. I've read the evidence to your lordship. I mean, that would be really repetition. But this is, Balas, directly the heart of the matter. Law says directly, Subramaniam Swami says directly, identifiable class, para 176. I read it to your lordship. Now, any application of that in any which way, as a matter of fact, your lordship has got smaller classes. This is the first case I'm coming across where the class is defined as 13 crore people.
Question not answered it on this one. It can't take in its embrace.
My learned friend, I read the written submissions last time. My learned friend argued in the sessions court. I read the written submissions. Written submissions specifically make this point. He orally argued it. The judge notes it. The learned judge notes it. There's no answer. There's no answer. If this is correct, then there is a jurisdictional error. So, I defame him by name, he doesn't file. He files saying that by defaming him by name, I'm defaming the entire class of people standing here. That's the whole thing.
In the order, it's not answered.
It is noted in particular in para small Roman 3 at page 67 of the learned sessions court order. In the revision 5. In the revision 5. I did read it last time, and I'll just remind again. Yes. This I told you last time again, but I'll repeat it again. This is an important point because point taken, point noted, but not answered.
Yes.
I'm only on the
last occasion you have pointed.
I am grateful.
67, 68,
No,
69.
I'm grateful. I'm grateful. I raise it. You can reject it. You can say it is wrong because of 1, 2, 3. You've not dealt with it. I can't show negative. Where have you dealt with it? You've not dealt with it. Then, the learned appellate court has suddenly relied entirely on this magic witness, which I told you last time, is this Yaji. And my learned friends say that he was the only virtue he has is he was present. Your lordship noted me last time at great length. I dealt with Yaji. I showed you the pages also. Yes. But just to remind lordship, two very simple things on Yaji. Yaji, your lordship will note, is a person who suddenly appears like a magic wand 2.25 years after the complaint. Point 1. Point 2, he is not in any list of witnesses. Point 3, he starts his deposition, and your lordship saw with me page 44 to 46 of the compilation last time. I'm grateful. I'm grateful. I'm grateful. He starts by saying, I'm a very strong pillar of the BJP. I have been for 40 years with the BJP. 45. I am now the cultural advisor to the Karnataka government. I have worked with the complainant in this position. I have done so many posts. A man, Manoj, with that background appearing 2.5 years later, suddenly, without being in the list of witnesses, Manoj, it's very easy to Manoj make a frame of conviction on that. Now, this all I showed to your lordships, the written submissions, page 666. Page 666, written submissions. Directly the point, same thing, taken again by my friend Mr. Chima, not answered, not dealt with. But Manoj, the learned court fully relies on Yaji, doesn't deal with any criticism of Yaji. As a matter of fact, Manoj, everything else comes down to Yaji, boils down to Yaji because
He has said only Yaji. He says electronic
Now,
evidence
Manoj,
will come today.
the answer given, just see the irony, Manoj. There is a whole host of witnesses. They are named in the beginning. None of them is found of any relevance. Most of them have not been there, they're not seen. Yaji appears, as I said, 2.5 years later, 2.25 years later. He's got a completely contradictory background. He obviously cannot be a sole reliable witness. Of course, he can be a witness if your lordship finds lots and lots of corroborative evidence. But Manoj, the main thing was the documentary evidence. The learned judge, I showed this also to your lordship last time, brushed it aside in 2 sentences saying, yes, it is there. We will see it at the end of the trial. We will see it later. So documentary evidence is out. Yaji is in. Credibility, believability, corroborative is 0. The documentary evidence, if it is inadmissible or not valid, had to be dealt with at this stage. Because you are using Yaji to convict me, to deny me non-suspension of conviction, then documentary evidence can't be brushed aside like that. That's the point.
Lord, today also, Mr. Nanavati has only.
And my lordship has heard today, I was told when I was coming in the car here, that Mr. Nanavati's prime witness is the magical Mr. Yaji Mills. Rightly, well, I mean, he cannot find a new witness now. Whatever is there is only this. With all his forensic ability, even he can't find a witness.
I don't want to eat.
Malas, therefore, even today, your lordship has got only this Yaji. He's a very infirm basis to not give me suspension of sentence. The sessions court, forget the trial court. I will win by trial, I will lose by trial, etc. The sessions court has to deal with it, Malas. Otherwise, what's the point? Then, Malas, kindly see that just a few more things will be done. I have made the point about the 65B certificate.
Yes.
Your lordship has noted it down.
Yes, sir.
It is well considered a technicality, but there are case after case after case, especially after Justice Nariman's judgment of the IT Act, that it's a mandatory provision. It's not that it's just something your lordship thinks it's technical and brushes it aside. Please produce 3 things. 1, maker certificate prepared by the maker of the CD. There is a CD, there is a maker of the CD, and there is a certificate. Where do the 3 match? Please show to the court. And the certificate issued while producing the CD in open court, it is admitted in writing at page 52, 53 of the CC that the CD was in open condition. Open condition, my lord, remember. Well, let me come to a more important point as I wind up, Wallace. The more important point is that your lordship, Wallace, ultimately, I have, Wallace, the duty to, Wallace, request my lords to consider and decide the suspension one way or the other, Wallace, at your lordship's immediate and earliest convenience. Well, I am here seeking a stay. I am gravely and irreversibly prejudiced without a stay. In my humble and respectful submission, Willis, it brooks no delay. We have now, everybody has argued. Your lordship, Willis, may kindly take a call this way or that way. Your lordship, Willis, may appreciate that denial. And of course, my lord is entitled to do one other thing subject to that. My lord is entitled to give an interlocutory decision and then a final, which is not normally done. And be very candid, not normally done. but some decision which clarifies my status today is vital. According to me, your lordship has heard us both at great length. Your lordship has seen at this level at 389, my lord is not a trial judge or a conviction judge or acquittal judge. Your lordship is a 389 judge at the moment. Your lordship has seen enough. Your lordship should come to a decision one way or the other. That is my humble submission, because that justice would be required. Yashwant Sinha's case was a Supreme Court order. It was in existence at the time of sentence. Now, that is what they are saying. I am asking myself one question on Yashwant Sinha's case.
671.
Yes. This is fully dealt with at page 671 of my written submission. If you also will just turn to that for a minute. Because this is again something apart from Yaji, my learned friend relied a lot on Yashwant Sinha. I repeat, my experience is more limited. There are people here with criminal law more experience. I have yet to find a conviction in defamation at all, or if at all, more than 3 to 6 months. To say that maximum punishment is desirable, what is it desirable for? It's a first-time offender. How is maximum punishment desirable? And how many defamation cases has the lordship found where 2 years is imposed? I mean, your lordship, in the sense, appellate court, but it's coming from below. Your lordship doesn't hear the trial. There is no defamation case that I know where the maximum punishment imposed for the first time. And your lordship is told that we have to cite a case to show that this is the most apposite punishment. Yashwant Sinha cannot be an apposite punishment test. Now see 671 written submission. Just turn to 6. But there is not a single reason given factually or contextually as to why Yashwant Sinha mandates that your lordship gives a maximum of 2 years, because 1 year, 11 months and 29 days is not enough. Therefore, give 2 years to a first-time offender for a bailable, non-cognizable, anti-societal offence. There is no reason given to your lordship. It's just said Yashwant Sinha. Now kindly see 671. I mean, Singh, it's not Yashwant Sinha. I'm told it's Yashwant Singh. I see. Yes. The same man. Same man.
It's the political.
I have not argued that.
The most disturbing, just see 671. I thought there's a mistyping here. It's Singh here. It's actually Sinha. The most disturbing feature of sentencing part is the manner in which the prosecution placed reliance upon the judgment in Yashwant Singh, and the uncritical manner in which the court readily signed the dotted lines. It has been pointed out in the memorandum of appeal that the said judgment would not have any bearing or relevance to the question of sentence in the present case. Now, this is the answer. Because the law applicable to the present case does not permit reliance upon observations made in a case of contempt of court. Your lordship is doing contempt of court, well as apples and oranges, or well as bananas and oranges. However, the real pain of the appellant lies elsewhere. The questioned speech relating to the institution of the present prosecution was made on 13th of April. The name of the appellant figured in the Supreme Court because of the alleged content much later in the year. This point I made, 6-9 months before and subsequent. The appellant was warned and told to exercise caution in future on 14/11. It baffles comprehension how, for a warning on 14/11, the appellant could be expected to be wiser on 13/4. Retrospectively, I said last time. Therefore, well, it's the what is recorded in the order is that when I'm giving you something more because you already stood warned on the date of giving you the punishment. Yashwant Sinha being present is neither here nor there. It's irrelevant. The jurisdictional error is, that the trial court is saying, I'm punishing you, Mr. Accused, because you were earlier warned by the Supreme Court. You stood warned. The dates show that there is no correlation at all. It's much later. Therefore, the answer can't be that on the date when I'm giving you the punishment, Yashwant Sinha has come. It's irrelevant. The 2 and 2 don't add up together. Whereas I would say, at the end of the day, just give me a minute. Just give me a minute.
In keeping with
Don't worry. Don't.
my apology.
Well, is this, I will move the application for suspension of sentence. Suspension of sentence, well, here, your lordship. Perhaps here,
We
your
are
lordship
not
need not
imposing
grant,
it.
well, for at least till the
In
rising of
High
the
Court,
court.
perhaps we are not now
No, Till the
imposing
rising
any
of the court, your
penalty.
lordship need not suspend the sentence.
Another even convicts a mistake.
Malas, if Malas, these considerations form a part, as I've shown, then Malas, it becomes very, well, I've also shown a whole set of 6 circumstances of vitiating of the trial. This Malas raises a grave doubt and apprehension about the purity and the fairness of the trial. I would beseech my lord Malas, this way or that way, for your lordship to decide the matter and give Malas quietus to this. And any delay of a single day, Malas, would Malas cause us
In fact,
extreme.
now therefore we have made clear that we have heard total all the parties and now we are keeping for judgment only.
I know,
During
Malas,
the-
I'm
during
making
these
one.
holidays, we are using all these materials and we are finally deciding. That's all.
Malas, there is only one request. There
Yes.
is only one request. I mean, I hate to
And
make. Malas,
today
I'm not-
again, the Honorable Apex Court has raised the very issue in the case of Muhammadullah Azam Khan.
Yes.
And the court has kept this matter in the month of July, where they have raised the very question.
Well, I am the counsel there.
Yes,
It is
therefore,
listed today.
therefore
three
I have
item
read
18.
that, therefore I am
I
now,
was to submit
No,
that,
no,
but
no.
Milord, it
No,
is
no,
all,
but-
once it is sub judice,
the
it is
court
sub
has
judice
already
either
posed
way.
that very
But,
question. And what is the offense in that Muhammadullah Azam Khan?
Murder.
No
Well,
murder.
not murder, sir. Very
Not
grievous
murder.
hurt.
He
Grievous
is
hurt.
just sitting on the road with his father, therefore the
No, Malas,
FIR is registered
Grievous,
against
grievous hurt. Malas, Grievous hurt. Grievous
That is
hurt
in
case.
the second.
10
But in
years.
the first offense, it was registered as,
No, Malas,
he is
I-
only aged 15 years at the relevant point of time.
Malas, he is given 10 years there and the High Court suspended the conviction. We are respondents in the Supreme Court. The other side is complainant is appealed. And that matter was today listed as court 3 item 18. I was to
That is
argue, it,
what I
Malas,
have
I have
read.
come here.
Hurriedly, and therefore I am
in
just,
mind was yesterday's matter before Malad when Mr. Sipal argued.
yes,
That was a different matter where Malad that's kept in July. That's different than
No,
this.
no. Today, Malas, I don't know what has happened when I came here. Today matter is listed before court number 3 is Justice Joseph's court. Where
no,
Malas,
that
I
is
have-
not the matter yesterday.
That
Ah,
was
that
different
is
what
now-
your lordship
that's
said,
a
when
different-
the son
But
was
anyway,
sitting with his
Milord,
father.
that is all,
No, but-
they are all
but
pending.
I'm not concerned. I'm on a
Arguments
different
are
point.
going
No,
on.
I'm on a different. No, in that one, the sentence stands suspended. The matter which I
Yes,
am doing.
Kerala High Court
Where the,
did that.
where the High Court of Allahabad has rejected and refused to entertain,
yesterday.
therefore
That
they
is
are
that-
approach.
That's right, but then I can equally cite. No, kindly see.
Mm.
I can equally, I'm entitled to cite
Yes,
that the Kerala High Court suspended it. After suspension for 1 month, the Malas Lok Sabha did not allow him to enter the. We Malas moved an application to court 3. On the day I moved the application, the Lok Sabha Malas came through Mr. Mehta and said, today we are allowing him to enter. So the disqualification lifted. It was immediately stayed and lifted. Now, Malas, I was different unpleasant duty to perform. Malas.
Yes.
I don't want to.
Mm.
Malas, it's my duty as a counsel to Malas request my lord to consider giving us Malas an order this side of the vacation because
this
Malas,
is not possible. In fact, when first occasion I have clarified that on 4th I am leaving the country and therefore I am unable to
no,
pass.
that is true.
Sir.
Your lordship Malas may only record then my submission.
Yes,
I'm only
certainly.
Malas saying that
Yes,
Malas, for all the reasons I've argued,
Mm.
Malas, some Malas, either interim or final order is required because everybody.
we
Malas, is
pass the
going to
final
recess.
order only after.
Yes,
your
your
plea of
lordship may only
vacation.
note my submission, Malas,
Yes.
this is a contention.
You know,
I have.
only there I may just.
Yes,
It's
Forbid
very
it.
clearly my submission.
yes.
That your lordship has also called for the recording.
I have already called for. the
No,
record.
therefore,
Yes.
you know, when the matter is being finally heard and being decided, you know, this prayer is out of place in my respectful submission.
We are
That's
So
all
my
right.
objection may kindly be noted.
My learned friend Abhishek has certainly been noted.
And
Similarly,
that will
my
amount to
submission,
allowing the
Yes,
petition.
my submission
You
that
can
your
be recorded.
lordship may Malas, consider deciding this side is fine, and we are in extreme emergency is my submission.
Yes,
I
yes,
only make it,
certainly,
that's
we record. That till the next council. Mr.
Without
Dr.
prejudice to all
Singhvi.
this, of course, we will file a written submission Malas, within 3-4 days in any case. That
But
we have.
now from 5th onwards, there is a holiday. Summer vacation is commencing from 5th. And
We
this
can file
court is,
it, no, can we file it by 4th?
but then I am unable to pass any order before that.
That's only for assistance below.
You can file. That I will
That's all.
go through the
Ah.
records and after passing and after going through your submission, I
Yes,
will
yes.
pass the order. You may.
One thing is saying,
Dr. Singhvi.
Not just one,
Yes,
Lord, sometimes they say, my Lord, in hunting a long shot. One shot which was taken by very, Lord, revered friend is
yes,
that this is a case of moral turpitude. Look at the judgment my friend cited. Kindly
Yes.
have a look at that. It's my Lord Sushil Kumar Singhal. The judgment should not have come. The argument, of course, is not made out. Lord, before my lords read it, my lord, the law is a judgment is not to be read like a statute. And the law further is a judgment is an authority for what it decides and nothing else.
yes.
Now, my lord, may kindly have
Hmm.
para 2. The facts and circumstances giving rise to the present case are that the appellant was appointed as a peon in the respondent bank, Cathal branch on such and such date. The appellant was handed over rupees 5,000 to deposit the same as dues for telephone bills. However, it was not deposited and FIR under section 409. Now kindly see my lord the para. It is
Yes.
a judgment which would my lord negate all that is being said. The para cited are my lord 32, which
Yes.
defines moral turpitude. Para 23 is cited. Let's
Yes.
read the para
Yes.
as it is.
Hmm.
Conduct that is contrary to justice, honesty, or morality in the area of legal ethics, offences involving moral turpitude, such as fraud or breach of trust, also termed moral depravity. Moral turpitude means in the journal shameful wickedness, so extreme a departure from ordinary standards of honest, good, moral justice or ethics as to be shocking to the moral sense of the community. It has also been defined as an act of baseness, vileness, or depravity. Then see sir para 24.
Yes.
Same. And then also see in para 24 the second judgment. So all this is taking it to the extreme, to the breaking point. This all would negate and would show that this does not fall in that.
The Senior Counsel, Dr. Singhvi, is requested the Honorable Court that since the Honorable Court has heard finally, then it is in the fitness of the thing that the interim order be passed in favor of the petitioner. In the interim protection be granted in favor of the petitioner. The learned counsel appearing for the original complainant, Senior Counsel Mr. Nanavati has objected this prayer. However, in the interest of justice, as the matter is heard finally, and all the documentary as well as the plethora of the documents is placed on the court, we considered the same. It is in the fitness of the thing that the matter be decided finally. No interim protection can be granted at this stage. Only after going through the records and proceedings, the final order can be passed. Hence, the matter is kept for final verdict after reopening of vacation. Matter is heard. Please.
very deeply obliged. We are very deeply obliged for a very patient hearing.
Immensely.
नमस्कार, मैं एडवोकेट वीके आनंद आपके लिए और भी ऐसे अच्छे कंटेंट और न्यूज़ लाता रहूँगा। हमसे बने रहने के लिए लाइक करें, शेयर करें, सब्सक्राइब करें और हाँ, फॉलो करना ना भूलें।